There is no feeling I get that's the same as when I walk into the U.S. Supreme Court's courtroom.
It's an amazing experience to get to argue in the Supreme Court.
Being in the Supreme Court, the significance and importance of the case is always on your mind.
You can hardly think of a subject that matters to you as an individual that will never come before the Supreme Court.
The landmark Supreme Court decision in Brown versus Board of Education.
The landmark decision that overturned Roe versus Wade.
Legalizing same-sex marriage across the land.
The Supreme Court takes a case because they want to figure out what the rule of law should be. Both sides will get the chance to stand up and argue.
It's kind of like a sporting event. There'll be some adrenaline rushing. You know, it's game time.
Now, how does this work? Obviously, you're going to edit this, right? My name's Roman Martinez. I'm a Supreme Court litigator at Latham Watkins, a law firm here in Washington.
Roman Martinez is really a very seasoned Supreme Court advocate. He's in his mid-40s, and he's already got 14 cases that he's argued before the justices. And he has the pedigree that you'd expect from an elite lawyer, so he went to Yale Law School. He then clerked for Chief Justice John Roberts. And then after that, he went to work for the U.S. Solicitor General's office, and that's the office that handles all the litigation before the Supreme Court on behalf of the federal government.
Our firm is representing Ava Tharp on a pro bono basis. She has a form of epilepsy that makes it extremely hard for her to communicate. She's essentially nonverbal.
When she was about 4.5 months old, she started having spasms. She always needed 24/7 care, and she has seizures every day.
When she was 10 years old, she moved from Kentucky to Minnesota, and she changed school districts. When she went to her new school in Minnesota, they refused to give her the same kind of accommodations that she had been receiving in Kentucky.
And it wasn't until the day before we started school that they told us that they would not adopt the Kentucky IEP, that they were going to remove services from Ava.
And so as a result, the hours of instruction that she was able to get were really cut down. And so they were much reduced from what she had received in Kentucky.
As time went on, Ava began to lose skills, and she lost her ability to communicate.
Thank you, Ava.
The case began 10 years ago when Ava's family argued that some courts have made it too hard to sue public schools when they don't accommodate students with disabilities.
Those types of plaintiffs, those kids, have to satisfy a higher standard than every other plaintiff with disabilities.
This case is about Ava, of course, but it's also about a whole host of other students who are similarly situated.
I was engaged in this case when Ava was still in the Court of Appeals.
As they teach you in grammar school, there are three branches of government: the legislative, the executive, and the judicial. At the top of the judiciary food chain is the Supreme Court of the United States. The big cases that the court hears every year go through a series of appeals through the federal courts.
The Supreme Court will decide cases where the lower courts have really disagreed, trying to provide some sort of national unity across the law.
Is there a circuit split?
In Ava's case, all courts agree that plaintiffs can get damages when there's been intentional discrimination. But where the courts disagree is what plaintiffs, here, Ava and her family, what they must do to prove that the discrimination has actually been intentional.
What we then did was bring the case to the Supreme Court, and we filed what's called a petition for certiorari.
There are several stages in the life of a typical Supreme Court case. The first one's going to be the petition for cert, asking the justices to take up the case.
Usually, when you're filing briefs in court as a lawyer, the goal is to just argue the merits of whatever issue you're arguing. A cert petition is different because the issue that the justices are considering is not whether you should win the case or lose the case, but rather whether they should hear it at all in the first place. And so you need to write a brief that appeals to their discretion. And so we're saying, hey, Supreme Court, you are here in part to make sure that federal law is interpreted and applied fairly and uniformly across the country. Because the lower courts are disagreeing about whether this is the right test, you need to step in and sort out this disagreement.
The justices will meet in a private conference. They'll talk about whether or not they want to take a case.
The Supreme Court is picky, the justices are picky.
There are thousands of cases that are appealed to the Supreme Court every year.
And they only hear a small fraction of those.
Basically, you have a 1% to 2% chance of getting your case granted.
So you need to convince them that your case is special and warrants their attention.
So we're racing right now in the week or so before Christmas, and our expectation is that the justices will consider whether to grant review in our case, whether to grant certiorari at their conference when they get together to discuss cases on January 10th. I'm very hopeful that the justices will see it our way and let us in the door.
It's about 3:50 in the afternoon on January 17th on Friday. I just got the news that the Supreme Court granted review in Ava's case, which is absolutely wonderful news.
Ava, yay!
Hey guys, how's it going? Hey, congratulations.
Oh, thank you for everything.
Oh, this is so exciting. You know, it's always exciting to get a cert grant, but especially in a case like this. Ava, it's good to see you.
I can't thank all of you guys enough.
After the orders list comes out and a case has been granted, then the attorneys are really off to the races. They have to write an opening brief. That's when they really do get to sort of how the court should decide a case and looking at all the precedents that weigh on the issue that they're being asked to decide.
We're going to be on a tight deadline, tighter than usual.
Under the normal briefing schedule, we would get 45 days to file our opening brief. The other side would get 30 days after that to file their response brief, and then we would have an opportunity to file a reply brief.
But because of the fact that this is mid-January and the court is going to have argument in the case in April, we're going to have less time than we would normally have to file our briefs.
And so it'll feel a little bit more like a sprint.
In addition, in parallel, we're going to be reaching out to Amici very soon to give them a heads up about the grant or requests for them to participate.
Amicus briefs are filed by parties that are not in the case yet, but who have a view on the question at issue. And they can be very helpful in sort of bringing additional arguments and perspectives to bear.
Now we're in the door. We just gotta get it over the finish line here and get the justices to see it our way.
So I got these quills from my first argument at the Supreme Court in 2014. A fun tradition at the Supreme Court, every time you argue a case, the clerk's office or the marshal's office gives you a quill. I grew up in New York City. My dad came to the United States when he was about 12 or 13 years old from Cuba. He was born in Cuba and came over right after Castro took over the country. My mom had grown up in New York, and that's where they met. When I was young, I always liked arguing. I would pretty much argue about anything. I had an uncle who was a prosecutor in Miami, and so I kind of learned about what being a lawyer might be like through him. There's some cases that are out there that are really not going to interest your normal layperson, but once you start looking at the law and looking at the precedent and looking at the history and some of the policy considerations, almost any case becomes interesting, or at least interesting to me.
Probably the case that he's most known for is this case called Loper-Bright. He was part of the team that overturned this long-standing administrative law principle.
This is a doctrine that was established all the way back in 1984, which essentially gave the power of agencies like this the ability to interpret laws that were vague.
Felt like a Super Bowl type of argument as far as Supreme Court arguments go.
He was the advocate who was arguing during the infamous toilet flush.
It is the toilet flush that was heard around the world.
Like a lot of us right now, the justices are working from home.
At one point during the hearing, something unexpected was heard as a lawyer was speaking. Listen closely.
And change these laws that apply to banks. And what the FCC has said is that when the subject matter of the call ranges to the topics, then the call is transformed.
I was not the one who flushed. I was busy arguing a Supreme Court case. It's certainly something I'll remember. I didn't wake up that morning having that on my bingo card. Hey guys. So listen, thanks for all the work on the brief. I think it's shaping up really nicely. So why don't we start on the accommodation issue? It's January 30th. The Supreme Court granted cert, I think, about 13 days ago. And so we have been hard at work, our team. We've internally come up with a plan for how we're going to pull our opening brief together.
There can be a few things that the lawyers are trying to accomplish. They're trying to ultimately get the justices on their side, either by convincing them that, this is the right way to interpret a statute, or this is, what the founders meant for the Constitution to mean.
We're trying to persuade them this is a case where you should rule for our client. It starts with kind of ideas, us brainstorming and thinking about how the brief, which is going to be, about 50 pages, about 13,000 words, how it should be structured. So we kind of work from a rough, kind of outline of the key points we want to make. And then the task is really to go and just sit down and write it. And that requires researching the case law, looking closely at the statutes that are in play, and then coming up with ways to explain how the statutes and the case law support us.
Because the Supreme Court has never weighed in on what standard applies to these kinds of claims brought by students with disabilities. You're focused a lot on the statutes themselves, but also canons of interpretation, accepted norms in the legal field about how these kinds of texts are interpreted.
I spend most of my day, I'm writing, I'm thinking about arguments for that narrow question. Like, that's what the Supreme Court's can be addressing.
The research part it's frankly a lot of reading, analysis, connecting dots. The writing is similarly somewhat of a monastic affair in the beginning.
They'll kind of divide up different pieces of it, and the associates will usually prepare jointly a first draft, and then I will look at it and we'll go back and forth. We'll just iterate on it. They'll send it to me in Microsoft Word. I'll turn on the comment tracking feature, and then I'll type in my changes. I'll rewrite things. I'll ask questions in comment bubbles, and then we'll just go back and forth. And sometimes that'll take 3 or 4 turns. Sometimes it can take 20 or 30 turns. I'm going to cut the doe citation. I think I like the regulatory site for the ADA, which is basically what FRI cites, and then otherwise generally keep it as is.
Along with the merits briefing, there's people who file amicus briefs, friends of the court.
What lawyers on both sides want is someone who's going to be a friend and amicus to them. So you want your amicus briefs to explain why your side of the case should prevail.
Some of these liberal and conservative groups will make it a point to file briefs supporting the point of view that they like.
I mean, I do think sometimes the group filing the brief's primary interest is to protect its interests, and those are not necessarily all that helpful to the court.
You'll see 20 or 30 of these in some cases. I think they have less of an impact now because there are so many of them.
The most important amicus is the U.S. government.
Anytime you can have the United States government on your side, that's a plus.
The Solicitor General's office manages and supervises all Supreme Court litigation on behalf of the federal government.
They used to refer to the Solicitor General as the 10th Justice.
They participate in so many cases, they have a unique credibility coming to the justices, and the justices trust what they're saying.
Anytime the Supreme Court grants review in a case and the SG's office has not previously participated or the federal government has not been a party, we start a very extensive process to solicit views across the federal government to try to understand how the legal issues in the case affect the interests of the United States.
And so their usual process after a case is granted in the Supreme Court is to invite both sides to the case and basically give them an opportunity to make a pitch for why the government should come in support of their side.
And I've been told that these SG meetings, from the party perspective, function as something like a moot court because the people in the room often ask really difficult questions that are probing the limits of the party's positions.
We went for about 45 minutes or so, then a separate Zoom the government had with the other side, and then they probably had an internal discussion.
The whole point of this process is to really try to get everything on the table so that we can make an informed decision about what will best advance the interests of the United States.
If you get them a lot of the way on your side, it's going to go a long way for your argument.
It's March 13th, 2025. I'm here in Arlington, Texas, where my law firm has our annual meeting of our partners. The big development has been we got an amicus brief from the U.S. government. They filed a brief last week, wholeheartedly supporting Ava's position in the case and essentially agreeing with our arguments. So that's a big deal to have the government on our side. The Supreme Court has announced that the oral argument in our case is going to be held on Monday, April 28th. That's the last week of the 2024-2025 Supreme Court term. It's April 2nd, 2025. We are here in my home. The ball's back in our court in the case. The other side filed its response brief on Monday. I always am reluctant to pick it up and start reading because you never know exactly what they're going to say, whether they're going to point out that you were wrong about a certain case or precedent or statute. The other side is not really disagreeing with us on our basic interpretation of the statute. But they've come up with some new arguments that they are going to hope the justices will consider and that are going to give us a lot to think about over the next couple weeks.
One of the things that was really unusual about this case was that the defendants really changed their position pretty late in the game. And so in their reply brief, they said not only would students with disabilities be affected by this case, but really everybody with disabilities. And that really raised the stakes for the justices.
The other side basically says, no, there's no uniquely stringent standard because the standard is stringent for everyone. And so we're going to join battle with them on that point. We have until April 18th to put together our reply brief. We get 6,000 words, which is going to be about 25 pages or so, to put our arguments together, and then that'll be the last word in writing before the court. My first case arguing in the Supreme Court was about a decade ago in 2014.
Mr. Chief Justice, and may it please the court.
I'd been in the Solicitor General's office for a number of months, so I'd been to a lot of arguments with my colleagues. But it was very exciting. This was going to be the first time when I was going to get a chance to stand up and argue.
Well, if that's what you mean, why don't you say exceptional injustice instead of gross injustice?
We're trying to tie the interpretation of the statute to the language
to the Senate report.
Not just to the Senate report, Justice Scalia, but to the judicial decisions.
It was a very hot bench, which is sort of the way that lawyers talk about cases when the justices are just firing questions at you one after the other. I thought, I want to get back in there. When can I do this again?
I think the best advocates are able to have a conversation with the court. And that means that there's a back and forth, and it's not a high wire act.
There's a lot of room in Supreme Court advocacy to think hard about how to make the case and what kinds of creative legal arguments might persuade this decisional body.
Appellate specialists know how to take a narrow legal question and build out an argument that doesn't span just a couple paragraphs, but builds out 50 pages.
My mentor, Rex Lee, who was the Solicitor General for Ronald Reagan, he would say, we bring the expertise in how to effectively communicate with the court, how to posture your arguments to be as persuasive as possible for the justices.
This is very high stakes stuff. And if you don't have real experience before the Supreme Court, you're taking your life in your hands.
Supreme Court cases differ quite a bit from cases in the lower courts. If we think about a trial court, really the issue there is you're arguing in front of a jury, you're trying to convince them of different facts. Once you get to the Supreme Court, usually the questions are all legal. Very little bit of the facts are going to come in, and they're usually not disputed at all.
So much of our work is developing the case for why our position is correct as a matter of law, focusing on the statutes, focusing on canons of statutory interpretation that support our position.
What if there was no precedent? What would we say about this as a matter of the Constitution itself? Not being a prisoner of the way in which other people have argued the case before or the way other judges have thought about the issues before can be really valuable. Jacket on. All right, let's get started. So thank you all for coming. Thank you guys for coming.
The Moot Court is really a trial run through the arguments.
The moots are, they're a lot of fun, and they're in some ways the most valuable way to prepare for these arguments. I've recruited really smart colleagues of mine in our appellate practice who have not, up until now, been involved in the case at all.
That's another wild part of this.
When I started arguing in 1982, and nobody in the SG's office did moot courts. And then Justice Scalia went on the court, and you went from getting about 10 questions in 30 minutes to getting about 10 questions in 30 seconds, which just created a much more active oral argument, which made mooting seem more important.
So you get people who are very knowledgeable in the area, and you have them sort of play the role of the justices.
This isn't like a dress-up exercise. There are no costumes. There are no funny accents or anything like that.
Am I right that Title I and Title III both specifically call for reasonable accommodations? I'm not at all trying to embody a particular justice, but I do think it's helpful to try to anticipate the questions that the various justices do.
The goal is to figure out what it is that the justices are going to ask you so that you can have the answers for them.
I will do the 2-minute opening if that works. Mr. Chief Justice, and may it please the court, the district has conceded Ava's question presented.
Counsel, you put a lot of weight on the idea that they have conceded the question presented. I guess I don't see that.
When we came and we briefed the merits of this case, as we said on page 30 in footnote 7, we weren't even going to address the issue of what standards should apply because our question presented was limited to that. So I think in context, it was absolutely clear to everyone.
If it was so clear, why did you preemptively include this footnote?
We were just indicating to the court that we didn't think it was making especially clear that it was not within the question.
But why would, I mean, if it was as clear as you're saying, why would you put that footnote in? So they're literally saying
two comments on that.
Anticipating this argument that you say is unimaginable that it could be made.
Okay, thank you guys. You guys are tough. It was hot. It was hot. Yeah, that's great. I mean, that's exactly the kind of moot you want to have, where you have people who are really smart and they're going to be very skeptical.
I tend to be a fairly nice guy, but I try to channel a little more aggression in my questions sometimes. And I don't understand how you can say that you lost on a theory that's completely wrong.
You know, if you go through something like that for an hour and 5 minutes of questioning, it makes it a lot easier to get in front of the justices.
So what's next? You know, what's your weekend like?
Tomorrow I'll work mainly from home for much of the day. And then Sunday I think I'll probably come to the office and work most of the day from here. And then get a good night's sleep both nights, both Saturday and Sunday.
Mr. Chief Justice, and may it please the court.
The district has conceded Ava's question presented. I had a great day yesterday. I came into the office early with my daughter Kobe, and she was helping me pull together and finalize my thoughts for the opening comments. We did a little rehearsal together a couple times, which was fun. What's going on over there? My family's great. I met my wife when I was a summer associate at another law firm, and we started dating the following year. All right, so what was up with you today? For a while there, I would get my wife to do a moot court for me here at home before every case that I argued.
Yeah, we used to do them for every single argument. Now you have too many arguments that can't keep up.
And so we'd get together in the evening, and the Chief Justice would have a glass of wine, and I'd be standing up arguing the case, and she'd be firing questions at me.
I'm presuming, is that the brief?
This is our brief here. Our argument is that the school violated Ava's rights under the American with Disabilities Act and the Rehabilitation Act because they didn't give her equal treatment. The kids are wonderful in general. I think it's kind of fun trying to think about how to explain some of these more complex cases and complex legal issues to them.
He's the best dad ever, and he always spends time with us, and even though he works really hard. And I know sometimes he stays up till like 4 a.m. in the morning, but just to make sure he has time to spend time with us.
Thanks, Kobe. You're not going to trade me in, is that what you're saying?
No.
Okay, well, it's 8:20 p.m. on Sunday night, April 27th. I'm just going to do a little bit more reviewing of my papers and then hopefully try to get a good night's sleep. So that's about it. See you tomorrow. Good morning.
How are you doing?
All right, guys.
Good morning. Where's my mom?
How you doing? Good.
More?
Oh, you look nice.
Thanks.
Hi. How's it going?
Okay, sleep.
I slept okay until about 5.
I tend to get up really early on argument days, usually about 5 a.m.
I am a big believer in having rituals leading up to a Supreme Court argument. I always have the same thing for breakfast, which is bananas.
It's better to not treat this the way I used to sometimes treat law school exams or college exams, where I'm up till 3 a.m. the night before, kind of cramming and trying to stuff everything in my brain. I'll try to wake up, either have quick breakfast with the kids or grab something on the way.
And then head down to the office because I've got adrenaline just flowing through my system.
The U.S. Supreme Court hears arguments today in a case about the federal laws that promise help for children with disabilities in public schools.
Argument day starts at 10 o'clock. You come up to this building that's got marble steps, a big marble plaza. Often the sun is shining right off of it. Flags are flying in the wind. It's a really majestic kind of scene. And then once you get into the building, you walk through these big doors into a courtroom that's ornately decorated. There's a lot of gravitas to it.
It's a really special experience to be in the courtroom.
I like to look around at the friezes and the architecture of the place. It's just, it's magical from my perspective.
The justices are up very high.
The podium where you stand to argue cases is quite close to the bench where the justices sit.
It's intimate.
You always know who your panel is going to be. It's the same 9 justices.
The petitioners in the case usually go first. In our case, that's us. So I'll speak first. Mr. Chief Justice, and may it please the court, the district has conceded Ava's question presented.
They have 2 minutes of uninterrupted time, and then they have a certain amount of time, usually about 30 minutes, to argue their side of the case, where the justices are going to be interrupting them and asking them questions.
It's usually rapid-fire questions from the justices. The argument doesn't slow down.
I like a hot bench in general, up to a point.
I take their point that maybe you need intentional conduct for an injunction, but I don't even know why you need anything else.
Right. Justice Sotomayor, we agree with that, the impulse underlying that question. I think those are some great questions for the other side. I think what I would say on this is that...
Yeah, but you're here.
Well, let me take a shot at it.
Well, the very first time Justice Scalia was on the court, he just came at me with so much more intensity than anything I had experienced.
Whenever that ends, it's time for the other side to go up. They also have 2 minutes, and then they have the round robin as well.
Mr. Chief Justice, and may it please the court, this court should affirm Monahan. Bare IDEA violations do not support liability under Section 504 or the ADA.
And then you have rebuttal, which is the final part where the petitioner has a few minutes just to make their closing remarks, really what they want to leave the justices with, what the lasting impression that they want to make. Arguments in this case started off pretty typical, but I think by the time that the school district's advocate got up there, I think the legal term for it is it went a bit off the rails. The advocate for the school district, Lisa Blatt, had accused the parents' attorney and the Solicitor General's office, who's on the parents' side here, of lying in the case. And that's something that really rubbed the justices the wrong way.
You believe that Mr. Martinez and the Solicitor General are lying? Is that your
an oral argument? Yes, absolutely. It is not true that we
you should be more careful with your words.
Okay, well, they should be more careful in mischaracterizing a position by an experienced advocate of the Supreme Court.
Justice Gorsuch admonished counsel to sort of watch her words and later came back to the issue, saying it was still bugging him. And after a very heated exchange, she withdrew her comment. But it was sort of a unique moment in the court that we don't see very often.
Lisa is a take-no-prisoners advocate, and it's fun to watch her. And in this case, I think she just overstepped for a moment.
There was a lot of heat at the argument. The temperature was raised a bit more than usually is the case in the Supreme Court. Lisa has been in touch. She's apologized, have accepted the apology, and we're moving past it. One of the most important moments in the argument was when Justice Jackson was asking my adversary, the district's lawyer, about the implications of the district's position. And she asked my adversary whether it really meant that they were saying that reasonable accommodations are not actually required under the law for people with disabilities.
Is your argument that bad faith should apply everywhere?
Yes, and the statutory text solely by discrimination is the reason for the action is a discriminatory intent standard.
The other side wholeheartedly accepted that that was in fact what they were saying. And I think there was maybe an aha moment there for some of the justices where they really appreciated the breadth and the kind of revolutionary and radical nature of what the district was asking for in the case.
And that would be a sea change, right? It strikes me as a pretty big deal.
Nowhere else have I seen the use of deliberate indifference or gross indifference used to define intentional discrimination.
I think today was a good day in the sense that we really got to make the points that we wanted to make.
It felt really emotional, even just coming into the buildings, and it really felt historic, like we were doing something really important. For a minute, I felt like I could cry. Like it felt, especially when Roman used Ava's name in court. It's like, that's my Ava.
Think about Ava, who desperately needs every precious hour of school so she can learn to communicate with her parents. We ask you to reject those radical arguments, and we ask you to vacate the decision below.
I think that the parents sort of have the upper hand here. I wouldn't be surprised to see an opinion in their favor.
It's dangerous always to, especially in a high-stakes case, to think that you know what's going to happen, and you can really get fooled.
I'm cautiously optimistic, but you never know. We'll have to wait and see what they decide to do.
The case is over. The argument's done. You walk out of the courtroom. It's a mob scene. There are tons and tons of people there.
Once a case is argued in front of the court, the justices will discuss it that week.
And then they'll take an initial vote. The justices who are in the majority, the one who's the most senior, will decide who it is that's going to actually write the opinion, and then that justice goes it alone for a while.
Then they exchange drafts back and forth, as many as 20 drafts sometimes.
They'll get comments from the other justices, the ones in the majority that say, hey, could you tweak this, or could you tweak that, or I don't think I'm going to be able to join this part. Could you just take it out altogether?
Once they all agree and everybody's gotten their dissents in and they're ready to go, they want to get it out as fast as they can.
The opinions are released on, random days.
I'm told that in the 1950s, they had a pneumatic tube, and they would send the opinions down to the press room by the pneumatic tube. That's not the way it is these days.
At 10 o'clock, the justices will be on the bench, and the person who wrote the majority will be reading a summary from the bench.
I try to go and be there when opinions are announced. If somebody very passionately dissents from what the court has done, they will announce their dissent and say why they're dissenting. It can be quite a dramatic event.
The way the court writes its decision, how broadly it rules or how narrowly, what things it might carve out, what questions it leaves open for the future, can really have a significant impact in helping to dictate what that ruling is going to mean for the law going forward.
There's not really a set schedule to when opinions are released. Most people know about the opinions from them being posted online.
We don't find out about the opinion any sooner than anybody else does.
I'm hitting refresh on the website. I'll find out when the world finds out.
Today is a Supreme Court decision day, so starting at 9:55, my colleague Kimberly, who is actually at the Supreme Court, will go into the press office, and they'll bring out boxes of opinions. Each box can have anywhere from 1 to 3 opinions. It's like a ball of nerves, like it's high pressure. It's stressful to have to kind of open an opinion and try to quickly read it and understand what the court is saying and has decided. Okay, here's Kimberly. It's Ames. Ames versus Ohio, right? It's a labor case. And then we just go back to refreshing. This is Smith & Wesson is the next opinion. Catholic Charities, that's mine. One more coming. Oh, it's Blombank. That's mine. They're done, right? That's the last one, Seth? I think they're done. Yes. Yeah, they're done. They're done for the day.
So no AGT today?
No AGT today.
It's Thursday, June 12th. It is about 9:57 a.m. The Supreme Court is issuing decisions today. It's a busy day. There's a lot of other stuff going on, but I've tried to keep the 10 a.m. window free for a little bit. But it could be very anticlimactic. We might not get anything, and that's part of the experience too. All right, 10 o'clock. Let's see. So, going to the Supreme Court website here. We'll do a little refreshing. Okay, we got a first decision for the day, not ours. It is Rivers versus Guerrero. Commissioner versus, this is a tax case from Justice Barrett. So this is another page here in the Supreme Court's website showing another way they show the opinions. They have this R number thing. So you know that there are going to be more opinions when they haven't filled in the R numbers for the day. So even though right now Gorsuch is reading, you might think, oh, well, is this the last one or not? And we know it isn't because they are still blank. So that's how the kind of insiders know that there's more to come. No, not us. We're gonna have a good story here about, we got four cameras, 3 distinguished news professionals, a light thing, and nothing's gonna happen. I don't know, maybe that's part of the story though. It's like, nothing happens. Then you have to wait for the next time. We have a decision. Our case. It's by the Chief Justice. Let's open it up. I think we won. All right. And I think it is unanimous with a couple concurrences. This is very exciting. I want to make sure I understand that. I want to understand exactly what they said. This is great. Aaron, how are you?
Hi guys, how are you?
Victory. All right.
Oh my gosh.
Very exciting. This is amazing. So congratulations. This has been a long road for you guys and for all of us. But this looks like a very strong decision. Now, I haven't had a chance to digest it.
I've skimmed it briefly. The majority tracks our briefing very closely and is a narrow decision that's only focused on the dual standards. Justice Sotomayor, in concurrence with Justice Jackson, questions whether there's any intent standard at all. And I'm just perusing Justice Thomas's concurrence now.
So, we had asked the Supreme Court to basically decide the question of whether children with disabilities in the educational context should be subject to a different standard, a more stringent standard. And we did not ask the court to decide what that standard that applies to everyone should actually be. And so we basically said, just don't apply a different rule to kids with disabilities in the educational context. That was the strategy, and we were helped in that because what the district then tried to do is they tried to make the case bigger than it was originally presented, and they tried to make it all about what that actual standard should be. And the court didn't buy that. They said, the district's changing its position, and it hasn't preserved these issues below, and they shouldn't be allowed to inject them into the case now. And so we're going to keep it narrow.
So will this now go back down to lower courts?
So the case isn't resolved. So the case goes back down to the lower courts, and her case gets to continue. So the lower courts said that she definitively lost the case because of this bad faith or gross misjudgment standard. And so that's been reversed. And so we think that under the correct standard, she satisfied that. Now maybe the district is going to say she hasn't satisfied it, and the parties will have to fight out, under the correct standard who should win. But we think that there's a lot of language, especially in the Court of Appeals decision, that supports Ava. This is obviously a very important case for the Tharps and for Ava. But you all have talked to our parents. More important to them was to get the issue resolved in favor of kids with disabilities, so that would be the rule going forward, governing everyone.
Well, I want to thank everyone. To think that initially it was just this case involved kids with disabilities, only to find out that you guys were defending every single person in the United States with a disability before the Supreme Court. And so what was on your shoulders was huge. And the fact that you guys were successful, not just defending the rights of students, but everyone with disabilities. I can't thank you enough. Gina can't thank you enough. And the disabled community cannot thank you enough for everything that you guys have done.
It feels great to wrap it up. First, we were trying to get the Eighth Circuit to change its standard. It's definitely been over a year, maybe a year and a half or so. And so it's been a long road for us. It's really been a great team effort. And to see all that hard work come together, and then to read an opinion that essentially says, yeah, you guys were right about how you framed the case, how you wrote the briefs, how you argued it. It's a great feeling.